I want to start today by admitting something. I spent a good chunk of last night sitting at my kitchen table with the stack of documents you sent over,
Mhm.
specifically the PDF about the DC Court's new order. And I had to stop, put my coffee down, and actually Google the date to make sure I wasn't reading, science fiction.
It feels that way, doesn't it? Like we've somehow stepped into a parallel timeline where things actually change.
It really does, because we talk about disruption all the time on the show. We talk about it in finance with crypto, disrupting media with AI, healthcare, you name it.
Sure.
But the law, the
Mm.
legal system is like, it's usually the place where disruption goes to die. It's slow, it's archaic,
Yeah.
and it's incredibly protective of its own
Oh, it's
boundaries.
a guild. I mean, historically, and we're talking for centuries, it has been a closed guild. You either have the golden ticket, the Juris Doctor degree, you pass the bar exam, or you are on the outside looking in, period.
Exactly.
Yeah.
And yet, here we are. It is Tuesday, February 17th, 2026. And less than 2 weeks ago, on February 5th, quietly, with no big media circus, the District of Columbia essentially took a sledgehammer to one of the oldest rules in the book.
We are talking about the monopoly. The monopoly on who gets to speak in court, who gets to give legal advice.
Right. And to understand why they did this, why they issued this thing, Order M29326, we have to look at the numbers. And this is where I just got stuck. I was reading the Delivering Justice report that the task force put out and the statistics on who is actually standing alone in courtrooms. They're terrifying.
They are. And before we even get into the percentages, we have to be super clear about what kind of court we're talking
Yeah.
about here. This is not law and order.
Right?
This isn't a murder trial where you hear the cops say you have the right to an attorney.
That's the Miranda warning. That's for criminal law.
Correct. If the state, the government, wants to put you in prison, the Constitution guarantees you a lawyer. If you can't afford one, the public defender's office steps in. It's not a perfect system, but that safety net exists.
Mm-hmm.
But what we are diving into today is civil court. If your landlord is trying to evict you from your home, that's civil court. If you are fighting for custody of your child, if you're trying to get a restraining order against an abuser, that's all civil court. And in that world, for the vast, vast majority of people, there is no safety net. You are completely on your own.
And that's where this number comes in. And I want you, our listeners, to really try and visualize this. You walk into a courtroom here in D.C. It's a high-stakes civil case. We're talking about whether you have a roof over your head or if you get to see your kids.
Life-altering stuff.
Life-altering. The source material says that between 75 and 97% of the time, there is at least one person in that room who is completely alone. No counsel, no backup. Just them against the system.
It's what we call the justice gap. And to be honest, gap is way too polite a word. It's a chasm. It's an abyss.
Yeah, it's not a gap.
When you have 97% of plaintiffs in probate cases settling a loved one's estate, or 97% of respondents in child support cases showing up without a lawyer, the system just isn't functioning as an adversarial system anymore.
What is it then?
It's basically an inquisitorial system where one side is armed with a lawyer, a professional, and the other side is, well, they're naked.
That is a stark image. Okay, so the mission for this deep dive is pretty clear. We have the official order from February 5th. We have the new legal rule they created. It's called Rule 49C14, which is a mouthful, but we're going to break it down.
We will.
And we have this massive 2025 report from something called the Civil Legal Regulatory Reform Task Force. So we're going to figure out how DC plans to fix this chasm using this new concept, the community justice worker.
And we're going to explore why this specific solution, the CJW, might just be the model for the rest of the country. Because what happened 2 weeks ago in D.C. isn't just a local rule change. It's a fundamental rethinking of what it even means to practice law.
Okay, let's dive into the crisis first, because I really don't think we can appreciate the solution until we feel the crushing weight of the problem. You mentioned this isn't criminal court. It's civil. When we look at that Delivering Justice report the task force was using, the breakdown of these numbers, it's honestly depressing.
It's evidence of a systematic failure, a complete breakdown. Let's just take eviction cases. Landlord and tenant court.
Okay.
The data shows that 88% of tenants walk in unrepresented. They come in holding a summons, maybe a crumpled lease agreement, and they have absolutely no idea what their legal defenses are. They don't know about illegal rent increases or breaches of the warranty of habitability. It's not their world.
And on the other side of the aisle, the landlord.
On the other side, 95% of landlords have attorneys. So it's not just a disparity, it's a near total imbalance. Almost every single time a tenant walks into that room, they are facing a professional, someone who does this for a living, someone who knows the judge, knows the clerks, knows the specific code section that lets them get an expedited eviction.
That's a slaughter. It's not a fair fight. It's like putting a high school boxer in the ring with a heavyweight champion and saying, well, the rules are technically the same for both of you, so it's fair. It's absurd.
It is, and it gets even more extreme when you move over to family court. We touched on this, but let's drill down. In paternity and child support cases, 97% of the respondents are unrepresented.
97. So 3 out of 100 people have a lawyer.
3 out of 100. And these are cases that will determine the financial future of a child, sometimes for 18 years. They determine the financial stability of a parent. And almost nobody has any legal guidance whatsoever.
And what about probate? You mentioned that too.
97%, again. 97% of plaintiffs in small estate matters have no lawyer. Now, probate sounds dry and boring, right?
A little, yeah.
But imagine your grandmother passes away. She didn't have a lot of money, but she left a small house or a little bit of savings. You're grieving. You're trying to plan a funeral. And on top of that, you have to figure out how to transfer the title of the house so you can sell it and pay the bills.
Right.
And you walk into court, and the clerk says, just fill out these forms. And the forms are written in a language that I swear hasn't been updated since the 1800s. Legalese.
And perhaps the one that was most heartbreaking for me to read about was domestic violence.
Yes. In domestic violence cases, 88% of the petitioners, so these are the people asking the court for protection, for a restraining order, they're doing it without an attorney.
So you have someone who is fleeing an abusive relationship. They're probably traumatized. They might have left in the middle of the night with nothing but a bag of clothes.
Often with their children in tow.
Right. They likely have no access to the family bank account because the abuser controls all the money. And we, as a society, expect them to navigate complex legal filing procedures, rules of evidence, service of process, all by themselves.
That's the system we have.
Yeah.
And the common assumption is, well, legal aid exists. Why don't they just go get a free lawyer?
Yeah.
People have this image in their head that there's this massive army of pro bono lawyers just waiting to take these cases.
Like a public defender's office for civil stuff?
Exactly. But the reality, which the task force report highlights in stark detail, is that there simply are not enough legal aid lawyers to go around, not even close. For every person legal aid can help, they have to turn away many, many more.
And here's where it gets really interesting for me, or maybe frustrating is a better word. I think there's this stereotype out there that this is just a poverty problem, that if you're officially poor, you fall into this gap, but if you have a job, a regular 9 to 5, you're fine.
That is a critical misconception, a really damaging one. The data shows that this justice gap extends well into the middle class.
The report specifically mentioned moderate income people, right?
It did. These are households earning between 125% and 400% of the federal poverty line.
Okay, let's put that in real-world terms. 400% of the poverty line. Depending on your family size, that's a decent salary. That's not poverty.
Not at all. We're talking about teachers, nurses, firefighters, maybe even some entry-level government workers right here in D.C. These are not people who are generally considered destitute or low income.
Yeah.
They own cars, they pay rent, they buy groceries.
And yet,
the report shows that 86% of their civil legal needs go unmet. It is basically the same failure rate as for the poorest demographic.
so why? I mean, that's the big question. If I'm making a decent salary, why can't I just hire someone? I hire a plumber when my sink breaks.
Yeah.
I hire a mechanic when my car breaks. Why is a lawyer different?
It all comes down to what the report calls lawyer economics. The task force looked at the average hourly rate for a lawyer in D.C. The estimate they used was $291 an hour.
$291.
And frankly, for an experienced litigator in this city, that is a very conservative estimate. It's often much higher.
Okay, so let's round it to the $300 an hour just for easy math. Let's play that out. Let's say I have a dispute with my landlord over a security deposit. It's a $1,500 deposit they won't give back.
Okay, a very common problem.
Okay.
So you call a lawyer, the initial consultation and intake, just to explain your problem and have them review the basics, that's an hour.
Boom. $300 gone.
Now they need to review your lease, look at the email chain between you and the landlord, and maybe check the D.C. Housing Code statutes. Let's be generous and say that's another hour or two.
So now I'm down nearly $900. I haven't even filed a single piece of paper with the court yet.
Exactly. By the time you draft the complaint, pay the filing fee, hire a process server to serve the landlord, and then show up for the very first status hearing. You have spent more on the lawyer than the $1,500 you're trying to get back in the first place.
It's economically irrational.
Completely. It is irrational to hire a lawyer for almost any consumer problem under, say, $10,000 or $20,000. The cost of the solution exceeds the value of the problem.
It's a total market failure. The product is priced out of reach for its target consumer.
It's a complete market failure. The supply of lawyers is artificially restricted by the bar exam and accreditation. The cost of legal education is astronomically high, so new lawyers have huge debt and have to charge high rates. It's a closed loop.
The report had this one calculation that really it blew my mind. It put the scale of this into perspective.
The $40 billion number.
Yes. It said that providing just 1 hour of attorney time to every household in the country facing a legal problem would cost $40 billion nationally.
$40 billion for one single hour of help.
Which tells you that the old model, the pro bono model, the idea that lawyers should just volunteer more out of the goodness of their hearts, is mathematically impossible as a complete solution.
It's a rounding error. It helps, and it's noble, but it cannot solve a problem of this magnitude.
You could mandate that every single lawyer in D.C. do pro bono work every single Friday, and you still wouldn't close a gap that size. The supply of lawyers is too small, and their cost is too high.
It's a structural problem that requires a structural solution.
So the system is broken, it's too expensive, it's inaccessible, and the result is that almost everyone is navigating it blind. The task force saw this data, they heard the testimony, and they realized they couldn't just say, do more pro bono.
They couldn't just tinker around the edges.
No, they needed a structural change. And so enter the solution, the community justice worker.
Or the CJW, as they're calling it.
Right, the CJW. So this order from February 5th, 2026, officially creates this brand new role. What exactly is a community justice worker? Because when I first hear community justice, I think of maybe a mediator or, a neighborhood volunteer. But this is much more formal.
Oh, much more formal. A CJW is, by the official definition in the order, a non-lawyer who is authorized to provide limited legal services.
A non-lawyer.
A non-lawyer. And the court's order is very specific about who these people might be. They aren't just random people off the street. The source text lists social workers, nurses, public health workers, librarians, teachers, clergy members, or other trained volunteers.
I have to say, I love the librarian example. I feel like librarians are the unsung heroes of the legal system anyway. They're on the front lines.
They really are. They're the de facto navigators for so many people.
You can just imagine it. People come into the library every single day. They go up to the reference desk and say, I got this eviction notice. What do I do? And right now, or I guess before this order, what does the librarian have to say?
Before this order, the librarian has to be incredibly careful. They can say, here is a book on landlord-tenant law. They can point you to a computer terminal with the court's website. But if they say, okay, you need to file Form 4B, and on line 7, you need to argue that the notice was defective because it didn't give you the required 30 days.
What happens then?
That librarian is committing a crime.
A crime?
Technically, yes. It's called the Unauthorized Practice of Law, or UPL. It is a strict liability offense in most jurisdictions. You are giving specific legal advice without a license. It doesn't matter if your advice is good or bad. The act itself is illegal.
So the system is actually criminalizing the only practical help these people could get.
Precisely. And that's the incredible frustration that led to this moment. You have all these trusted community members, pastors, social workers, tenant organizers, who are smart, they're capable, they want to help. They probably know the court forms better than some new lawyers do because they see them every single day.
Right.
But they were legally gagged by the regulations. The CJW program, at its core, effectively remove that gag.
So the CJW program decriminalizes helping people with their legal problem.
In a very specific, regulated way, yes.
Yeah.
Think of it like the medical model. This is the analogy that the task force used heavily in their report, and it really, really holds up.
Okay, explain that.
If you have a sore throat, or you have a cut on your arm that needs a few stitches, you do not need a board-certified cardiothoracic surgeon to look at it.
No. In fact, I'd prefer not to wait 3 months and pay $1,000 for a surgeon appointment for a sore throat.
Right. You go to an urgent care clinic, you see a nurse practitioner or a physician's assistant. They can diagnose you, they can write a prescription, they can stitch you up. They can solve the problem. They are highly trained, they are competent, but they are not doctors. They didn't go to 4 years of medical school.
And we as a society are totally fine with that. We have completely accepted that model because It works. It increases access.
Exactly. The CJW is the nurse practitioner of the legal world. You don't need a lawyer with 3 years of law school and $200,000 in student debt to help someone fill out a form to get their security deposit back. You need someone who knows that specific process really, really well.
Okay, but let's get to the powers they have. Because when I was reading the text of the new rule, Rule 49C14, I was genuinely surprised by how far they went. I expected them to be able to give advice. I expected them to be able to help with forms.
Sure, that's the obvious stuff.
But there is one part here that made me actually gasp out loud.
I know exactly which part you're talking about.
They can represent clients in court.
This is it. This is the game changer. This is the real disruption.
So they can actually stand up before a judge and speak.
Yes. The rule explicitly says they can answer questions from the judge, they can make representations on behalf of the client, and they can make legal arguments based on the facts and the law.
That breaks the monopoly.
It shatters it. For centuries, essentially, the only person allowed to speak for another person in a courtroom was a member of the bar, a licensed attorney. Now, a trained social worker can stand up in landlord-tenant court and say, Your Honor, my client has a defense under D.C. Code Section XYZ, and here's why.
That is absolutely massive. But, okay, I have to play devil's advocate here. I can hear the lawyers screaming from here, and honestly, I have a bit of skepticism myself.
Of course. It's a radical change.
You're telling me a librarian who took a training course is going to go toe-to-toe with a landlord's attorney who has been doing this for 20 years. Is that safe for the client? Is that really justice?
Dan, that is the visceral reaction, isn't it? How can they possibly be competent enough? But the task force and ultimately the court looked at this pragmatically. They looked at the reality on the ground. Remember that statistic from the beginning?
The 97% unrepresented.
Right. So the choice for that tenant is not librarian versus high-powered attorney.
Yeah.
If that were the choice, of course, you'd take the attorney every time. But that is not the reality.
Right.
The reality for 97% of those people is me, alone, terrified, confused, versus high-powered attorney.
Okay, that's a very fair point. So it's not a choice between a CJW and a lawyer. It's a choice between a CJW and nothing.
It's a choice between a trained, supervised advocate and absolute zero. And the court decided that some trained help is infinitely better than no help at all.
Okay.
And also, keep the scope in mind. These CJWs aren't going to be arguing complex constitutional theory at the Supreme Court. They're going to be handling specific, high-volume, repetitive types of cases.
Mm-hmm.
If you're a housing advocate who becomes a CJW, you might handle 500 eviction cases in a year.
You'd get very good at that one thing.
You might actually know the eviction code better than a general practice lawyer who only does 1 or 2 evictions a year as part of a much broader practice.
That's a medical model again, right? The paramedic is probably better at intubating someone in a moving ambulance than the brain surgeon is because the paramedic does it a dozen times a week.
Precisely. It's specialized practical knowledge.
But surely there are guardrails. They didn't just throw the courthouse doors open to anyone who wants to play lawyer for a day.
Oh, absolutely not. The guardrails are significant, and they're probably the most important part of this whole structure. The court was very, very careful here.
Okay, what's the first one?
The first and most important guardrail is the nonprofit requirement. You cannot just go hang up a shingle and say, Bob's Discount CJW Services.
So no private businesses, no for-profit motive.
None. A community justice worker must work for or be a formal volunteer with a designated nonprofit legal service provider. They have to be attached to a legitimate organization like Legal Aid or a well-known housing advocacy group or a domestic violence shelter.
And what about supervision? Is there a lawyer in the background somewhere?
Yes.
Yeah.
They must be supervised by a licensed D.C. bar member within that organization. So there's always a lawyer in the loop. That lawyer is responsible for the program, for the training, for the overall quality control. They're just not doing all the frontline work anymore. They oversee the casework, but the CJW handles the day-to-day client interaction.
And the cost? Can they charge the client?
No. This is critical. The services must be free or, in some cases, low cost to the client, and the CJW cannot personally accept any money from the client for their services.
So that eliminates the profit motive entirely.
It does, and it prevents predatory actors. It stops people from preying on desperate folks by promising legal miracles for a cash payment.
That directly addresses the notario fear, doesn't it? I saw that come up a lot in the community feedback sections of the report.
Yes, the notario concern. We should probably unpack that because it's a very specific cultural issue. In many Latin American countries, notario publico, A notary is a very high-level lawyer. They have significant legal power.
Right, but in the United States, a notary public is.
Well, it's the person at the shipping store who stamps your document for $5 just to prove that you were the one who signed it.
Exactly. It's a ministerial, non-legal function. But scammers exploit that linguistic confusion. They put up a sign in an immigrant neighborhood that just says notario, and people who are new to the country assume it means immigration lawyer.
And they get taken for a ride. They pay thousands of dollars. And the notario does nothing. Or worse, they file the wrong paperwork and get the person deported. It's a horrific form of fraud.
And the fear was that this would happen with CJWs.
The fear was that people would claim to be CJWs to scam people in a similar way. But because a real CJW can only operate through a legitimate nonprofit, and because they cannot take cash directly from the client, that risk is significantly managed. If someone on the street asks you for cash to be your CJW, you know immediately that they're a fraud.
Okay. Are there things they absolutely cannot do? Like if I'm facing a complex business litigation, can a CJW represent me?
No, absolutely not. First, remember, this is for civil cases only. No criminal cases whatsoever. But even within the civil world, there are very clear limitations written into the rule.
Such as?
They cannot conduct a jury trial. They cannot take or defend depositions, which is the formal questioning of witnesses under oath. They cannot conduct a full evidentiary hearing where you're cross-examining witnesses.
So if a case actually goes to a full-blown trial with witnesses on the stand and cross-examination, you still need the lawyer to step in.
In general, yes. The lawyer would have to take over for that phase. The CJW is there for the high-volume procedural hearings, the initial hearings, the status conferences, mediations, settlement negotiations.
Which, frankly, is where 90% of these cases are resolved anyway.
Exactly. Most cases never go to a full trial. They get resolved or they die in the paperwork and procedural phases. The CJW is there to make sure the client survives the paperwork and has a voice in those early critical stages.
Okay, so that's the CJW. It's the medical model. It's nonprofit, it's supervised, and it's targeted at the huge population of people who can't pay. But the task force report discusses this other option that they did not approve yet, the LLP.
Right, the licensed legal practitioner.
This sounds similar. It's another acronym. It's a non-lawyer, but it's actually a very different beast, isn't it? And this is where the report shows that things got a little spicy.
It is very distinct in a few key ways. The LLP model, which exists in a few other states like Arizona and Utah, is designed to be more of a market-based solution.
What does that mean?
It means an LLP would be an independent professional. They would not necessarily need to work for a nonprofit. They would not necessarily need direct supervision from a lawyer for every case. And crucially, they could open their own business and charge fees.
So this would be like creating a new tier of legal professional. I could, say, get an LLP license and open a shop, your neighborhood divorce filer, and charge, I don't know, $100 an hour to handle simple, uncontested divorce paperwork.
That's the idea. Or handle small business contracts or landlord-tenant issues for a fee. And that is precisely why it was so controversial. The task force was unanimous on the CJW idea. Everyone, liberals and conservatives, agreed it was a good thing to help the poor, but they were deeply split on the LLP.
Why the split? I mean, if the goal is access to justice, why not let the market try to solve it? Why not let entrepreneurs come in and offer a service that undercuts the high-priced lawyers?
Well, the court's final order on February 5th essentially tabled the issue. They said, we're going forward with CJWs now, but we need further study on LLPs.
They kicked the can down the road.
They did. And the hesitation came from a few places. First, the economics of it. There was a real concern that to make a living in an expensive city like Washington, D.C., an independent LLP would have to charge at least $150, maybe $200 an hour just to cover their overhead and pay themselves a salary.
Which brings us right back to the original problem. If I can't afford a lawyer at $291 an hour, I probably can't afford an LLP at $200 an hour either.
Exactly. Is there actually a viable market there? Or would it just create a low bono tier that is still out of reach for the very people who need the help most? It doesn't solve the problem for that teacher or that nurse we were talking about.
And I'm guessing the organized bar, the lawyers themselves, were not thrilled about the potential competition.
That was a very significant factor. The survey results included in the report were clear. Private lawyers were the single group most opposed to the LLP idea. They raised a number of concerns, but the one you heard most often was about creating two-tier justice.
Okay, what is the two-tier justice argument? Unpack that for us.
It's the idea that you're creating a system where rich people get real lawyers with a JD, and moderate income people get these sub-lawyers or lawyer lights. The argument from the bar was that the poor and middle class deserve the same gold standard of full representation as the rich, and creating this second class of legal provider is a cop-out. It cheapens the brand of justice.
But isn't the current system already the ultimate two-tier justice? One tier is you get a lawyer, and the other tier for 97% of people is you get absolutely nothing. It feels like the lawyers are defending a gold standard that almost nobody can actually afford to use.
That is the powerful counter-argument. And it's the one that the task force and the court eventually leaned into when they approved the CJWs. But for the market-based LOPs, the court decided to pause. They want to see data. And I think they looked at Washington State, which is the big cautionary tale here.
What happened in Washington?
Washington State was the first in the country to really try this independent paraprofessional model. They called them limited license legal technicians, or LLLTs. It's a big experiment. But after a few years, their Supreme Court sunsetted the program. They shut it down.
Why? What went wrong?
At the end of the day, it wasn't financially sustainable. The regulatory costs to create the exams, license the LLLTs, and oversee the program were really high. And not enough people signed up to become LLLTs because they did the math and realized they couldn't make enough money doing it to justify the training and licensing fees. It was basically a failed business model.
So DC is playing it safe. They're saying, let's start with the nonprofit, volunteer-based model first, and we'll study the for-profit model a little longer.
It's a prudent approach. Establish the infrastructure of training and supervision first, through the nonprofits. See if it works, see if it's safe. Then, if it is, maybe you can consider expanding it to the private market.
Let's pivot for a second to the community feedback. Because the task force didn't just sit in an ivory tower and invent this. The report says they went out and held over 20 focus groups with real people. And some of the quotes in the report are really telling about how people feel about lawyers and the legal system.
The recurring theme, over and over, was what I would call the trust gap, or maybe the intimidation gap.
Calling a lawyer is so intimidating. That was one of the direct quotes that really stuck out to me.
It is. The legal system is opaque by design, almost. The language is archaic. The procedures are confusing. And lawyers, to many people, can feel distant, or judgmental, or just expensive. If you're poor, or if English is your second language, walking into a fancy downtown law firm feels like walking into a trap.
But a CJW is different.
A CJW might be your caseworker at a community health clinic who you've known for 5 years. It might be a deacon in your church who you trust implicitly. It might be the head of your tenants association.
That's the brilliance of it. You're using people who are already trusted members of the community. You don't have to build that trust from scratch.
Exactly. There's another quote from a community member in the report that I highlighted because it just sums up the entire problem. The person said, "If you can't afford a lawyer, you can't afford justice."
Wow.
That raw sentiment is what drove this whole initiative. The community was basically screaming at the legal system, "We don't care about your professional monopoly or your fancy degrees. We just want some help we can understand and afford."
Okay, I want to get into the nitty-gritty of the rule itself now, Rule 49C14, because the devil is always in the details. When does this actually go live? When do we see the first CJWs in court?
The effective date is April 6th, 2026. So in about 6 weeks from when we're recording this, it's coming up very fast.
And if I'm a social worker and I hear this and think, I want to do that, can I just sign up online tomorrow?
No, not at all. The training requirements are strict and they are mandatory. The rule mandates that any nonprofit wanting to have a CJW program must create a comprehensive training curriculum. And it has to cover 3 specific buckets.
What are they?
First, substantive law. You need to actually know the housing code or the debt collection statutes or the rules for getting a civil protection order. You have to be an expert in that narrow area and probably pass a test on the law itself.
Okay, that makes perfect sense. You have to know what you're talking about.
Second is procedural training. This is the really practical stuff. How do you actually file a document with the court's e-filing system? Where do you stand in the courtroom? How do you address the judge properly?
The stuff that, ironically, law school actually doesn't teach you very well.
Ironically, yes, exactly. And third, and this is very, very important, is ethics. The training must have a robust ethics component with a specific focus on confidentiality and conflicts of interest.
This was a big question I had. If I tell my lawyer something, it's protected by the attorney-client privilege. They can't be forced to tell the police. They can't tell the other side. Does that same privilege apply to what I tell my CJW?
Yes, and this is a huge deal. The order explicitly confirms that the traditional attorney-client privilege extends to communications with these non-lawyers.
So it's legally protected.
It is absolutely vital. If a client tells their CJW, okay, the truth is I didn't pay rent because I lost my job and spent the money on something else, that is a secret. It's confidential. If the CJW could be forced to get on the stand and testify against their own client, the whole relationship of trust would crumble. The client would never be honest with them.
So legally, the cone of silence covers the social worker just as completely as it covers the lawyer.
Exactly right. And that required a specific change to the local evidence rules, which the court included in this order. It was a very thorough package.
There was also a specific note in the order about law students. Now, law students have always been able to practice in clinics under supervision, right?
Yes, under what are called student practice rules. They can act as student attorneys. But the order creates a specific tweak for them. Law students can become CJWs, but if they do, they have to notify their law school. And they can't double dip. They can't use the CJW rule and the student practice rule for the same activity.
Why that distinction?
It's to prevent confusion about what hat the student is wearing at any given moment. Are they a student attorney working for their university's legal clinic, or are they a volunteer CJW working for a separate nonprofit? It's a small technical detail, but it shows how much thought went into the regulation to avoid loopholes or confusion.
Okay, let's zoom out for a minute. D.C. is often seen as a unique jurisdiction. It's a city, it's a federal district, it has its own weird set of rules. Is D.C. alone in this? Is this just some quirky experiment happening inside the Beltway?
Not at all. In fact, D.C. is actually catching a wave that started on the other side of the country in a very different place. Alaska was really the pioneer here.
Alaska. That seems random.
It makes perfect sense if you think about the geography of it. Alaska has these huge rural areas, remote villages, that are only accessible by plane or by boat in the summer. There are literally zero lawyers in thousands and thousands of square miles. If you don't let trusted community members provide some level of legal help, then nobody gets any help at all.
So it was pure necessity. Necessity was the mother of invention.
Exactly. Alaska started their Community Justice Worker program, they use the same name, all the way back in 2019. They authorized trained local people to handle things like simple wills, domestic violence orders, and disputes over public benefits.
And how has it gone?
It's been a massive success story. They now have over 500 CJWs working in 47 different communities across the state.
500. Wow.
It is. And it proved the central point.
Yeah.
The sky didn't fall. The legal system didn't collapse because non-lawyers were helping people fill out forms and speak in court.
So who followed Alaska's lead?
A bunch of states started their own experiments. Arizona created a role called Certified Legal Advocates, specifically for domestic violence and housing cases. Delaware created Qualified Tenant Advocates, specifically for eviction court.
I didn't know about Delaware doing that.
Yes, and Utah has a program for medical debt and domestic violence. Just recently, South Carolina approved a program that allows NAACP-trained advocates to represent people. So this is becoming a national movement. D.C. isn't the first, but because it's the nation's capital, its move is highly visible. It's joining what people are calling a regulatory sandbox to see if we can democratize the law.
Democratize feels like exactly the right word. It's a recognition that legal knowledge shouldn't be a secret held by a guild. It belongs to the community. But, okay, looking forward, it's not going to be an easy path, is it? We have the rule, we have the April 6th date. But what are the roadblocks? What could go wrong?
Implementation is going to be the hard part. The rule is just words on paper. The courts have to appoint a monitor to oversee this whole program. But the biggest, most immediate hurdle is funding.
It always comes back to the money.
Always. The nonprofits that are supposed to run these programs, Legal Aid, Bread for the City, groups like that, they're already stretched incredibly thin. They're constantly fundraising just to keep their existing staff of lawyers. Now we're asking them to also build brand new training curriculums, recruit and vet volunteers, supervise them, and manage the liability for them.
And who pays for that? Who pays for the trainer's time? Who pays to print the materials? If I'm a nonprofit and I have to spend 40 hours of my staff's time training a volunteer CJW, that is a real cost. That's time they aren't spending on a client's case.
Exactly. The focus groups in the report raise this point repeatedly. There is no big pot of government money attached to this order. It authorizes the activity, but it doesn't fund the infrastructure. It will likely fall to philanthropy, to private grants, and to the nonprofits themselves to scrape together the resources to make it work.
So the risk is that the program exists on paper but is empty in reality.
That's a real risk. If the funding isn't there, you might only get a handful of organizations that can afford to stand up a program. It might not reach the scale needed to actually make a dent in those 97% statistics.
And meanwhile, the LLPs, the for-profit option, are still waiting in the wings.
They are. The court specifically ordered a reconstituted task force to keep studying the LLP idea. They didn't kill it. They just said, not yet.
So there's a path forward for them,
I
potentially.
think so. If the CJW program is a massive success, and if the data in a year or two shows that these non-lawyers are effective and safe, that will build a lot of confidence. Then you might see the court approve a limited pilot program for LLPs, maybe just in one area of law, like family law, to see if the market-based model can work here. The door is cracked open, but it's certainly not wide open yet.
So let's try to wrap this all up. As of this month, February 2026, the very definition of who can help you in court in Washington, D.C. has officially fundamentally changed.
It is expanded. The monopoly, after centuries, is over.
And for you, our listeners, whether you are a tenant or a family member in a dispute or just someone who is interested in how our society works, this really matters. It's a formal acknowledgement that the legal system, as it was designed, has been broken for a very long time.
For decades, we've tried to fix it by just throwing a little more money at the problem. More funding for legal aid, more pro bono requirements, and it hasn't worked. The gap just kept growing.
It was a Band-Aid on a gaping wound.
Right. This is the first really structural attempt to fix the problem by changing the players on the field. It's a shift from a lawyer-centric model to a consumer-centric one. It finally asks the right question. What does the person in crisis actually need to solve their problem, rather than what do lawyers want to protect about their profession?
I want to leave everyone with a final thought to chew on. We talked a lot about the medical model, nurse practitioners, and paramedics. We completely accept that now. We can't imagine a modern hospital functioning without them.
It would be impossible.
So, if this CJW program works, if a social worker can successfully and safely represent you in an eviction, and a librarian can help you win a debt collection case, will we eventually look back at the requirement to have a 3-year Juris Doctor degree for every single legal matter as an outdated, inefficient relic? Are we right now witnessing the unbundling of the legal profession?
It is the single most important question in legal reform for this decade. And if DC gets this right, the answer is probably yes.